session.
Please be seated. Welcome. We are here today in our case number CV190358, Shook v. RenewCare et al. Counsel, you each have 20 minutes for argument. You may save time for rebuttal if you keep track of it. And please, both of you, tell us who you are and who you represent when you begin your argument. And with that, let's begin.
Good morning. May it please the court and counsel. My name is Michael Ryan, and I represent the Osborne defendants in this litigation. We're here today, Your Honor, because of the error that the trial court made in denying the Osborne defendants' motion to compel arbitration. The most important point is that Mrs. Shook was competent and able to grant authority to her daughter, Ms. Farnes, in order to be her agent for purposes of completing the admission paperwork that included both arbitration agreements.
What is our standard of review on that?
It's a mixed standard, Your Honor. It's a standard, obviously the formation of a contract.
Now I'm talking about the decision that she was competent. What is our standard of review on that?
The standard of review is...
I'm sorry, incompetent is what the court...
Yeah, the standard of review is that it had to be supported by substantial evidence.
And we only reverse if it was clearly erroneous, correct?
Yes, that is correct. That is correct.
And I assume you'd acknowledge that's a pretty high threshold for you to reach.
It is a high threshold unless the standard for competence is completely misapplied, which it was in this case. And that goes to the Gallagher case that we cited. If the court remembers that case, the man had just had a stroke, he was an alcoholic, and the court still said not only was he competent to make an agency, which is far simpler, but he was able to appoint a power of attorney. And that was effective. And so the standard here was misapplied. And I do want to jump to that area because I know the court was interested in a healthcare decision and what that means. And that aspect goes to assuming that she is not competent because the healthcare power of attorney only comes into play if she is not competent and if she is unable to make her own decisions. So we believe that the court erred in relying solely on Dr. Smith, and the Gallagher case is very much on point. But let's go there first because I think that's...
Well, I think you're right, though, that it's phase one and phase two, and our question was not to suggest that we come to a decision on phase one. So tell me your best argument, because I'll be candid with you that it seems to me when trial court hears the evidence and hears an expert, we defer generally to that finding. So tell me your best argument quickly that the trial court erred.
Absolutely.
And tie it to the facts that were presented, the evidence that was presented.
Mrs. Shook was alert and oriented, not only according to her medical records that were from Osborne, but according to her own daughter, Mrs. Farnes, testified in her deposition that her mother understood and could make her own decisions. Now, again, I want to go back to the fact that this is a grant of agency. That's not even understanding the nature of the admission packet or anything else, because Mrs. Farnes was never going to go through that. What did she say? What did Mrs. Shook say to Mrs. Farnes? You do it. You take care of it. That was an express grant of direct authority for her to go through the admission process. And I would like to point out a case.
But that grant is preceded by the question of competency, isn't it?
The grant is preceded by the ability to make it under the standard of Arizona law.
Whether you're competent or not to make it, to say that, correct?
That is correct.
Okay.
And under Gallagher,
And so we have a record, an evidentiary hearing?
we have an evidentiary hearing, yes.
And we, this court, we look for reasonable evidence in that record. Now, the evidence might be better for you than it is for them, but that doesn't mean we can do anything, right? Because if there's reasonable evidence in the record to support the court's decision, we have to affirm.
I would suggest that assumes that the correct standard for competency was applied. That is a legal standard, Your Honor. That's a legal standard. And that is why the Gallagher case is so important, because in the Gallagher case...
Counsel, I want to let you get into Gallagher, but just up front to clarify, are you saying that the trial court used the wrong standard or used the right standard and applied it wrongly?
No, the trial court used the wrong standard.
Okay. No.
And that's because the trial court relied specifically and solely on the expert, Dr. Smith.
Wait, the trial court, as I recall, ruling noted your own Osborne's medical records.
Right.
That said that the plaintiff was, or not the plaintiff, the decedent, I'm sorry, was confused and disoriented at the time of admission. So it wasn't just the expert's opinion. There were other factors that the trial court relied on.
Your Honor, but however, the trial court also had before it, and at the time of admission wasn't when the arbitration agreements was signed. That's important. It was signed on the 23rd.
Yeah, but the authority that you allege was granted was done at the time of admission when she said, you take care of this. So why would it matter what happened that it was 5 days later?
No, that actually is not the case. The authority was granted at the time that the admission paperwork was given to her, which was on the 23rd.
I'm sorry, you're right. Okay, but it was the statement of you take care of this is what
Right.
granted the authority.
And so that's on the 23rd. So if there's confusion on admission, that doesn't mean there's confusion on the 23rd. We produced all kinds of evidence that showed that she was alert and oriented. And that was before the trial court. But more importantly, Ms. Farnes, who knew her mother better than anyone, she specifically stated, my mother made her own decision. She could make her own decisions. She could communicate. And so then, really, when it boils down to it, you have Dr. Smith, the expert. And he's brought in, and guess what? He's provided the records they want him to see. He never sees Mrs. Shook or evaluates her.
And you pointed all this out during your cross-examination of him. And so the
Right.
trial court had this and decided that it still found his testimony to be compelling.
But back to the legal standard. What is the legal standard that the court applied, and what do you believe the legal standard should have been?
The legal standard that the court applied was based upon solely what Dr. Smith said. And essentially, he arrived at conclusory allegations that he didn't believe, in his expert opinion, that she was able to grant authority.
Counsel, let me ask you, maybe this is not correct, but did Osborne's records say the patient was confused and disoriented?
In some places. And on
Okay, so
admission.
that is evidence, right? I mean, you had just said this is all about this expert, and that's why this happened, but I just mentioned 2 bits of evidence outside of that.
And Your Honor, we talked about that. That was at the time of admission, but on the 23rd, there wasn't that evidence that she was confused. But what we also need to be careful of is, to say confused does not mean you can't make decisions or understand the nature of the transactions that you're entering into. And that's where Gallagher comes in. So now I'm going to answer both of your questions, because you asked, okay, what should the legal standard be? It's set forth in Gallagher. So long as the nature of the transaction can be understood by the person, then that person is competent. In Gallagher, they did the same thing. They retained an expert, never saw the patient, reviewed some medical records, concluded not competent. Can't enter into the transaction. The court granted a directed verdict, so as a
Didn't
matter of...
Gallagher determine that the expert had not actually reached a conclusion about competency?
The expert actually said, in my opinion, he was not competent to understand the nature of the transactions. And this court reversed.
And it said that the expert had fell short of expressing an opinion about competency.
As a matter of law. Because even though the man had had a stroke and was an alcoholic on certain days, they said there was no evidence that he didn't understand the nature of the transaction. That is the standard. It is not a high standard.
But this expert actually opined that she did not understand at the time of this happening.
But so did the expert in Gallagher. I can find it for you, but essentially the conclusion of the expert, in my expert opinion, was not able to understand the nature of the transaction. The court said that was conclusory, and in fact, that was not the standard to be applied. So Gallagher...
Why you keep emphasizing a stroke? It seems like dementia and strokes are two different things. Stroke does not necessarily affect your ability to comprehend things. It affects your ability to do things. But why is that so telling to you?
Well, Mrs. Shook had a stroke. And dementia, again, is not something that precludes people from understanding the nature of the transaction. You can say a lot of people have dementia and still make all kinds of decisions.
So counsel, I don't want to hurry you along, but you have only 9 minutes and 8 seconds. Can you go to that healthcare power of attorney?
Yes, I certainly will. Now, the healthcare power of attorney, the argument is, well, this is not an arbitration agreement is not a medical decision. And I think it's important to look at the actual power of attorney statute that grants the powers. And it's very broad, and that is ARS section 36-3223.
Right, it says healthcare decisions, all healthcare decisions.
All health, and that
But
it's...
then in the definition of an agent, who's the person who's actually empowered under the power of attorney, it seems to narrow that a little bit and says healthcare treatment decisions. So help us understand, is there a difference, or is healthcare treatment decisions just another way of saying healthcare decisions? Is decision to waive an arbitration agreement a healthcare treatment decision?
Yeah, it is another way of saying healthcare decisions, because if you look at the powers granted, the 3223 says that the only limitation on the agent's ability under a healthcare power of attorney is set forth in the document, and it has to be expressly set forth in the document itself. Any limitation.
The only limitation on the ability to make healthcare decisions.
Exactly.
Not all decisions. She couldn't sell her house.
Right.
Could she have settled, let's say on the day that they entered, they butchered a insertion of a needle into her arm, and it caused her a lot of pain and suffering, but didn't kill her. Could the healthcare power of attorney have settled that claim that day?
Absolutely. Absolutely. Because
you think they could actually settle the say, we'll take $500 for that?
Without question.
How is that a healthcare treatment decision, to say, I'll take $500 for the damages you caused?
Because it relates to the provision of healthcare. And I think that what the temptation is to construe that in a very narrow way. But the whole admission packet.
How is that treatment, though? That's what I'm... And if healthcare treatment decision is not the same thing as healthcare decisions, then help me understand how it's treatment.
Well, the healthcare decisions relate to anything that has to do with the healthcare provided, including, as I set forth here, we have the admission agreement that says, okay...
Counsel, you're limited on time. So let's assume, from what Judge Morse is getting at, that there is a distinction between healthcare decision and healthcare treatment decision. Help us understand how this would fall under a healthcare treatment decision.
Because the arbitration agreement is part of the admission packet that Osborne has.
But it's optional,
all
right?
Hospitals have.
Right, but they're not compulsory, or at least here it was not compulsory, right?
It's optional because of Broomer.
Because of what?
Broomer, the
spell
Arizona Supreme Court case Broomer, Broemmer.
Okay.
If you look at that case, one of the main highlights of that case was you cannot condition the signing of an arbitration agreement on receiving treatment. And this court very recently, even after I filed my reply, so I want to bring this to your attention. This is Rizzio, R-I-Z-Z-I-O, versus Surpass Senior Living LLC. It's 2020 Westlaw 479342, decided January of 2020. In this case, a healthcare power of attorney signed for an arbitration agreement. And this court, now, granted, the issue of agency was not before that, that was not in Rizzio. But if you look at paragraph 34 of that case, it says Georgiana's signature on the agreement was explicitly not a condition of treatment for Rizzio. Further, Georgiana has handled matters related to Rizzio's healthcare since 2010 and testified that in her capacity as Rizzio's power of attorney, she had previously executed other agreements.
Power of attorney or health care?
It's talking about healthcare, so it is healthcare power of attorney.
Right, we concede if it was a power of attorney, we wouldn't have an issue.
But there shouldn't be an issue either way, and that is because as part of any healthcare organization, you're going to have admission paperwork that relates to finances, that relates to other ancillary things. And those things can be signed because they're part of the admission process. That's the important thing. And I do have some cases that...
Again, if it's optional, and this is what seems to be the distinction that most of the other states have reached, that an optional healthcare power of attorney is not a healthcare decision because you can get the treatment, you can get the healthcare regardless of whether you enter the agreement. So all those cases are wrong?
They are, Your Honor, because essentially the reason we have that is because of the Bromer case. Are we going to put arbitration agreements and nullify them both ways? In Bromer, it said, if you don't have...
No, you could have a general power of attorney that would grant it, but healthcare power of attorneys are limited to healthcare treatment decisions.
There are other cases that disagree with that.
Yeah, I know,
and I have
split,
those.
yeah.
And
Let me ask you a question, because you said they could settle a claim, a personal injury claim related to medical malpractice. If she decided to sell her house to help pay for the health care, could they do that as well?
No, because that's not part of the...
Why not? If they need the money to give her the treatment.
But it's not part of the admission process.
But where in the healthcare power of attorney does it say admission process?
It does say that. It says
How is
everything.
settling a claim part of the admission process?
In the healthcare power of attorney, it says to act as my agent for all matters related to my health.
Yeah.
Admission
But you
is
said
part of...
settling a claim after admission would be part of the healthcare power of attorney.
Well, settling the claim after is because it's related to health care that was provided to her by the facility.
And she wants to stay in there more than their insurance will cover, so she decides to sell her house to keep paying for that.
But I think that goes outside. I mean, at some point they're asking...
So there is a line at somewhere.
There is a line.
So it's not anything just indirectly or remotely related to health.
Right. It has to be ancillary to the admission or other treatment process at the facility.
Even if it's completely optional.
Even if it's completely optional, absolutely. Even if it's completely optional. Now, I have 2 minutes left, and I didn't say everything I wanted to, so I better reserve my the rest of my time.
Thank you very much.
Thank you very much, counsel. Let's see. Ms. Bossi.
Good morning.
I will admit, I thought you were the plaintiff or the appellant in the last case when you were sitting there. So I was surprised to see you at counsel table. I don't know why that's relevant. It's not, but go ahead.
Actually, I know my time's running, but I was here because Mr. Ryan's son, that was his first appellate argument, and I've known him for years too, so we came early to watch him.
He
do
did a great job.
His argument, so.
Oh, wow. Give him one more second. Wonderful. Well, congratulations on that. Go ahead.
Good morning. Again, my name's Melanie Bossi, and I represent Millie Shook and her daughter, Susan Shook, who's her personal representative of her estate. I had a whole outline, but I think I'm just going to go really to the meat of the coconut. This is not the first time that this issue has been argued in front of Division 1 and Division 2. They were both memorandum decisions, but I think they give the exact persuasive and analysis that this court has been asking Mr. Ryan. The first case that I just want to reference is the Hearst matter, which was a Division 1. It was written by Judge Downey, and they actually went through the exact analysis this court wants to take us through, because they reference the 36-3231 definition and the healthcare power of attorney statutes. So Division 1 says, in rather cursory fashion, Silver Creek contends Hearst was authorized to act as mother's agent under 36-3231, which confers authority on an adult child to make health care decisions for the patient. If the adult patient is unable to make or communicate health care treatment decisions, even assuming that Silver Creek had properly preserved this argument for our review, we disagree with them. The statute confers authority to make health care decisions, and they put that in quotes. Whether to agree to an arbitration is not a health care decision, particularly where, as here, the agreement to arbitrate is not a condition of admission or treatment.
I want to walk you through something that's given me some pause.
Sure.
Or some difficulty, I should say. So we cannot favor nor disfavor arbitration agreements. We should treat them the same as any other contract. Is that a fair statement of the law?
That is a fair statement.
Okay. Aren't you asking us to kind of treat them differently?
No, not in this case. I mean, first of all, you have to have authority to enter into a contract. So that's why you go
Right,
back.
I acknowledge that, but we're talking now, the definition, if we say that healthcare decisions does not include arbitration agreements, is that disfavoring, favoring, or treating them neutrally?
Treating them neutrally. Because obviously, again, you have to go back, you have to have the authority, and the only authority in this case is either the healthcare power of attorney or, and we'll talk about it, you take care of it issue, and I'll get to that in a moment.
Right, that's the factual underpinning.
Correct.
So would it be a healthcare decision if Mr. Shook had said, hey, I know it's extra, but I want my mom to have a private room at the beginning?
I don't know the answer to that. I don't
I mean,
really.
it seems optional. She could, I presumably wants her mom to have a private room because she thinks it's going to give her more comfort, better standard of care, something we would assume. So that seems to me to be an optional treatment decision.
Well,
And so if we presume that she may make the decision to enter into an arbitration agreement saying, if something goes wrong, I want the, what we assume is the less expense and speed of arbitration to resolve those claims later. Why wouldn't that be the same type of decision?
It's not, though. Obviously, having a private room is not waiving someone's constitutional rights to a jury trial. I mean, so this arbitration agreement, on its face, says it's optional, and it also says it's not a precondition of receiving treatment. So their own language from their arbitration agreement excludes it from being a medical treatment decision.
That's because we have cases that say they have to. If counsel is accurate.
After years of litigating arbitration agreements in a nursing home, there's a plethora of case law to say they need to state that. But not only Hearst. Now you go to Division 2, did the same analysis in that case. My client was actually an attorney who had
So, counsel, let me ask you, Bromer, okay, there's a case that says a healthcare institution cannot, as a matter of accepting, cannot condition the provision of healthcare on entry into an arbitration clause. Is that correct?
I believe so.
Okay.
If I'm following.
So, if we take that, it would seem to color or answer what is sort of, I guess, the national sort of assessment, which is it's a healthcare decision under a healthcare power of attorney if it is conditional for admission, right? It seems that the states talk on the optional condition. So I don't recall Bromer being argued, or it might have been, but was there anything in Bromer that would answer or color that second question? Was Bromer, I mean, I would suppose it was aimed at important policy considerations. We want people to receive health care treatment. Did it have any underlying or express treatment of issues that would be relevant in the arbitration context nationally? The question of, is it optional or compulsory?
No. From my memory of Bromer, it wasn't optional. It was a part of receiving treatment, and obviously that's why the court held that it was not an enforceable arbitration agreement.
Right. So, I guess what I'm saying is it would seem that Bromer, if we accept it without delving into the rationale, means a healthcare power of attorney can never provide the authority to enter into an arbitration agreement at admission.
Well, actually, though, Bromer, because it was either plastic surgery, it was the person themselves that entered into the arbitration agreement. A healthcare power of attorney did not come into play in Bromer.
Right, but it's the holding of Bromer says you cannot condition entry into here the nursing home upon an arbitration clause. Okay, and if that is the crux of the inquiry nationally, to determine whether a healthcare power of attorney provides the authority to enter or not, does Bromer mean, now going back to my point, that a healthcare power of attorney can never provide authority in Arizona to enter an arbitration agreement?
No, I agree. A healthcare power of attorney, which is limited to making healthcare decisions, does not give the authority to sign an arbitration agreement waiving that person's right to a jury trial. It's limited to healthcare decisions. So that's why you have the plethora of case law.
But if you could weave in Bromer, okay? Because what if your colleague made it compulsory? Bromer didn't exist. It would seem that would be a different question.
See, for me, it's hard to weave in Bromer since Bromer did not utilize a healthcare power of attorney. The person themselves entered into the arbitration agreement.
But it answered the equation used nationally to answer this question, which is, did you have to sign the arbitration agreement as a condition of entry or not?
No, I mean, obviously not in this case, because the arbitration agreement itself says it's optional and that it is not, it's not preconditioned for treatment or admission.
Okay,
what if the power of attorney in this case, the healthcare power of attorney in this case, said healthcare decision, I think it actually says health decisions, not healthcare decisions, but it said health decisions, including alternative dispute resolution and settlement of claims. What would our situation be then?
Then that would be probably a different story, because it's not just a healthcare power of attorney. It's a combination of a healthcare power of attorney with a general power of attorney. So that's where.
So the parties could still, even though Bromer wouldn't necessarily prohibit people from doing broadly, but they would need to avail themselves beyond the healthcare treatment decisions of allowed under the statute for healthcare power of attorney.
No, exactly. I mean, I've conceded arbitration agreements which have very specific general powers of attorney to settle, arbitrate claims, but that's more of a general power of attorney instead of a healthcare power of attorney. So, but your question, those two are combined.
What should, and I don't know if this is necessarily presented to us, but what should the nursing home have done differently in this case? I feel kind of almost bad for them in a way. They had someone who arguably was or was not competent. They had a daughter there who had some facade of a parent agency maybe, although they didn't really argue that, they argued implied, and a healthcare power of attorney. What should they have done in this case?
One, don't feel sorry for them. They've been putting forth arbitration agreements in nursing home cases and signed.
Should they not be allowed to?
No.
I think that's Judge Morse's point, is that a nursing home, corporations, this is sort of common, the U.S. Supreme Court has been pretty clear about not treating arbitration, not disfavoring arbitration agreements. So if they are going to have these agreements, what should they do?
If you're going to rely on an agent, you do so at your own risk and peril. So this is a 200-bed, 200-facility national chain. So if you're going to rely on agency, you need to make sure that the agent has authority. And there's been cases nationwide where the nursing home actually petitioned the court to have a guardian appointed if there was not someone that could answer for a resident.
Right, but that's neither efficient or realistic in every instance, right?
But the bottom line is,
No, I
If you're
understand
gonna-
the bottom line, which is the onus is on you to establish agency. But, I mean, here we have facts. We have
If you'd let her finish the answer to my question, I would,
Oh,
I would
sure.
kind of like to hear it.
yeah, no.
What else could they have done?
I was going to, yeah.
what they could have done is you have to determine who actually has authority. So if they find out, I'll get to the competency, obviously that was a factual finding. We did an extensive evidence.
We'll move past that. They didn't determine that whether or not let's assume they found she wasn't competent. So could they have relied on the healthcare power of attorney at that point?
No, because it does not confer authority to sign an arbitration
So
agreement.
what should they have done then? Assuming she's competent, you've got a healthcare power of attorney that doesn't convey enough authority. So what could they have done at that point?
If she's competent or not competent.
Not competent. They determine she's not competent, and they look at the healthcare power of attorney and go, dang, it doesn't say ADR. What do we do?
You don't have anyone who has authority to sign it. You can't present it to someone who does not have authority. So since it's optional and not a precondition for treatment, then they can't present it to someone unless
so our
they have
ruling
authority.
would
So the nursing home should have a per se bar in that instance going forward. All nursing homes in the state of Arizona should not accept patients under that circumstance.
No, I disagree. You got to take it case by case, and you got to take it of, does the person have authority?
Well, presumably if it's optional, they would accept them either way. They could
Correct.
never avail themselves of ADR if the person's incompetent.
Right.
But if the nursing home has a preference for ADR, then the most likely efficient result of a decision in that regard would be to say exactly what Judge Weinsweig said, which is if you have a not competent individual and they only have a healthcare power of attorney, they don't get nursing home services because it will be in the nursing home's interest to have a bar in those cases if you don't have an agent that can sign the agreement or that can take up the agreement.
Well, no, they're still going to, using their own agreement, they're still going to have to admit them and treat them. They just don't have a person that has the authority to bind
Are they not
the
permitted
resident
to
to an
decline?
arbitration agreement.
Are they not permitted to adopt a policy to decline a patient under these circumstances?
They could adopt a policy on that circumstance if they want.
And wouldn't a decision saying under these circumstances, you nursing home do not get to prefer ADR, wouldn't that incentivize nursing homes to then adopt policies to that end? We're not going to accept these patients.
Well, it would incentivize the nursing homes to ensure that you have someone who has actual authority to waive someone's right to a jury trial.
But if there's someone who's clearly incompetent and they don't have a power of attorney, what do nursing homes do today?
Literally, and it's true that they petition the court for a guardian and have someone appointed that can make the decision for that incompetent person. It's happened nationwide.
So they're not in those situations, they're not declining coverage for people.
No, correct. I mean,
And Brommer would presumably preclude them from declining coverage.
well, and I
Because if
also
it's
think
optional-
Medicare and Medicaid, and
Do you, I don't, this is taking us a little bit of the field, but would you say that Brymer is still good law after the series of United States Supreme Court cases after that case, talking about cases like that that disfavor arbitration agreements specifically are not acceptable? I mean, I guess we've gone really far down a Bromer road.
Yes, we-
Without considering whether it's actually still operative.
it's an older case. I think it's specific on the facts of Bromer and the situation that that young lady was placed in and signing it. Obviously, arbitration case law has come a long way since that decision has come out. I'd like to also point the, I call it my Patterson case because I can't pronounce the client's, the attorney's last name, still even when I represented her, I couldn't pronounce her last name. Again, that case, Division 2, goes through even more analysis as to a healthcare power of attorney not having the authority to waive someone's constitutional rights to a jury trial. And then it also goes on, it cites Hearst, and it also cites numerous other cases from other jurisdictions that all hold the same way. Those two cases are right on point. And since my time is limited, I do want to go and talk about Judge Cohen's analysis. He took extensive analysis of this matter after an evidentiary hearing. Mr. Ryan wants this court to believe that he made his opinion solely on Dr. Smith as an expert. Now, mind you, if the defense did not put forth an expert to controvert Dr. Smith's testimony. But you've got Dr. Smith, and you have also within the record their own nurse who evaluated Ms. Shook and said she had dementia. I would not give that person informed consent. She's disoriented ×3. She's got dementia. All of these other facts in the record is what Judge Cohen, who's weighing the credibility and making a decision that Mrs. Shook did not have the comprehension or the ability to confer authority to her daughter by saying, take care of it. I go on to also cite in the two main cases that's in the pleadings on identical, you take care of it, one being a husband. This is the Kindred versus Henson and the Gentry versus Beverly cases that go on. One's a husband and one's a child, and both of these opinions say, just because you say you take care of it, does not lead to waiving someone's constitutional rights to a jury trial. In addition, the Henson court, because in case Mr. Ryan wants to argue preemption, the Henson court talks about that the FAA does not preempt state law contract principles, including matters concerning the authority of an agent to enter into a contract, which parties may be bound by that contract. Bottom line, you got to have authority. And
You said something just a second ago, I wanted, before you
Sure.
finish up.
Judge Morse.
Aren't the courts split on whether this is a healthcare decision or not? You said I think you said something like all the courts or the courts have decided.
No.
Because when on our research, we found at least Colorado, I think Tennessee and California have come out the other way.
No, agreed. In New Mexico.
In New
I
Mexico.
litigate in New Mexico, and there's a case in New Mexico. But obviously, the plethora, the majority of all the states, and even when you look at the Patterson Y case, they go through the analysis that a healthcare power of attorney does not give itself to agreeing to an arbitration agreement. It goes through the analysis of the cases from different jurisdictions. Bottom line, I would ask the court to uphold Judge Cohen's ruling in this matter. He did an extensive analysis both in his first minute entry and on the reconsideration of this matter, and nothing's changed. Thank you.
Thank you.
Thank you, Mrs. Bossy, Ms. Bossy.
But I'm not.
She kind of is, actually.
All right, let's hear from Mr. Ryan.
Yes, I do not have much time, but I think that the crux of it really does come down to what is a nursing home supposed to do in situations like this. As this court knows, many of the residents are going to have some degree or another of some type of mental or cognitive disability. If there's no power of attorney, does that mean that arbitration agreements can't be utilized? And if that's the case, then that really is discriminating against arbitration agreements.
Do you agree with your colleague that there is a path, and the path is to go to the court and have a guardian appointed?
You know what?
Is that the only path? I guess, if you can answer that as well.
Yes, I will. I disagree with that because a guardian is a whole nother ballgame. To get a guardian appointed, you have to be essentially non-cognitive completely.
When you're, and I'm not calling it a parade of horribles since I'm the one who brought it up, but that's a kind of a term of art for purposes of argument. But isn't that the same with like emergency rooms where you have tons of unconscious, I mean, completely incapable? It's not even a question of whether they could make a decision because they're unconscious when they're brought in after a car accident. And
Right.
we accept that and move on.
We do for treatment. That's exactly right, because there's a statute that allows the family members to make decisions if there's no designated person to do it.
And does the statute allow them to enter into binding arbitration agreements?
The statute is completely silent on that, but certainly it allows them to enter into admission agreements. And so what if you have some kind of a dispute about what to pay, and that goes to arbitration? Whereas that could go to arbitration under an arbitration agreement, or that could be litigated. I mean, and they could say the same thing. There was no authority for this person to do that. There was no authority for them to accept or consent to this. So really it is discriminating against arbitration agreements. And you have family members who go in, they are representing, they have the authority. Mrs. Farnes testified she did when her mother said, you do it. You take care of the admission paperwork. So from a policy standpoint, and Broomer is, I know we talked a lot about the case, and it was cited, but we didn't go into this detail. It really does put the nursing home between a rock and a hard place, because you have to be optional, and yet that's one of the reasons they use to not actually enforce it or grant authority. Thank you.
Thank you, Mr. Ryan. Thank you both, counsel, for your helpful, informative arguments. We will take it under advisement, and with that, we are adjourned.